Good morning, ladies and gentlemen. On behalf of ProTeam and APSO, I would just like to welcome all our clients to our webinar this morning to discuss the burning issues and changes in our labour law coming up that impacts on flexibility. As a short introduction, I am going to introduce you to our presenters today. We have Ati Buertas, who is the APSO Compliance and Operations Executive. Ati heads up compliance and operations for APSO, having previously worked as an independent IR consultant as well as an HR/IR manager for a large transportation company. Ati completed his LLB in 2006 at the Northwest University and was admitted as an attorney at the High Court in 2008. Ati also completed his LLM in Labour Law through UNISA in 2013, with his dissertation focusing specifically on the second generation outsourcing and the impact of Section 197 of the LRA. In his current role, Ati also provides support and guidance to CAPES and also offers advice and consulting services to staffing companies like ProTeam and our clients and end-user clients. We also have Natalie with us today. Natalie Singer has been involved in the staffing industry since 2002, having previously worked locally and internationally in journalism, communications and marketing. She holds a BA in communication and several industry-related qualifications and has run her own successful recruitment business. Natalie regularly works with staffing companies and end-user clients to assist in improving efficiencies and creating mutually beneficial relationships for business success. So we're very proud to say that on today's webinar, we've had 50 registrations. I think we'll still have some people coming online as we go. But just to emphasize that we really would like it to be a very interactive session. So we're going to start off with a presentation and overview that focuses on the global importance of flexibility. Then we're going to discuss some options and the impact of the changes on your business. And then the most important section is around questions and answers. And we invite you to raise any questions that you might have. We do have the questions that were submitted with your registrations, but if there's any question that comes up or as you view the presentations and the options, please raise them so that everyone in the webinar can share from your question and experience. So welcome again to everyone, and I'm going to hand over to Natalie.
Thank you very much, Vicky. Just in terms of the questions, for those of you that might be new to the GoToMeeting, you'll see on your panel you have a chat panel and you have a questions panel. So as a question comes to you, if you just type it into the questions panel, we'll be able to see those, and at the question and answer section of our program, we'll then be able to address all of those questions. So welcome and thank you. What I'd like to do is just give you a very brief look into the changing world of work, and in particular the impact that it has on flexibility. And I think we'll all agree that the business world is changing daily. And because of the flux that's happening not only in economies, but certainly in the changes around globalization, the volatility of markets, the fact that we're dealing with new environments, new sectors, which obviously require new skills, we're constantly having to look at how we run our businesses as effectively and as efficiently as possible. And a lot of that has to do with deciding what is core business, what is non-core business, and also looking at what are permanent staff we require to make sure we continue with our business, and then obviously having the ability to bring in specialist skill when we need it. And certainly when it comes to scarce skill that's expensive, we can't afford to have these people often on our books for long periods of time, but certainly for the particular part of the project that they're involved in, or where it's about seasonal fluctuation, etc. Of course, the changing demographics of the world are also making life interesting, with increasing numbers of young people coming to the market who potentially aren't yet skilled or experienced enough and who require some kind of training. And in particular, our industry has a lot of good stories to tell about helping people access the world of work, gaining skill, and then obviously gaining experience and becoming good contributors to the economy, as well as obviously boomers who are getting to a point in their life where possibly they don't want to work full-time anymore and would like to be able to put their skill to use in short bursts or on contracts, and everything in between. So in terms of the research was conducted by a company called the Boston Consulting Group, which is an international market research company, very well known. And it was commissioned by an organization called CET. CET is the International Confederation of Private Employment Agencies in the world, and to which APSO belongs. This was commissioned in 2010-2011 and published in 2012. And really it looked at the adaptation of change to the world. And as we know, obviously from 2008 to 2009, we've had global chaos when it comes to economies, with things going up and down. And in particular, they looked at how labor market functioning is improved by having regulated and efficient private employment services that are able to help end-user clients like yourselves have access to the right skill at the right time to be able to take up opportunity. This piece of research is available in an electronic format on our website, and I will be sharing it with Vicky and her team at ProTem, and I'm sure that they will send you the links or make them available to you post this presentation. Just a couple of key slides, if I may, from the research is really just looking at how modern economies and labor markets have three distinct dynamics these days. One is obviously the issue of seasonality and the fact that many environments work on a seasonal fluctuation cycle where you obviously need to upscale and downscale your operations in accordance to your need. The cyclical nature of economies, and I think we're seeing that specifically or intensively in South Africa, where we're seeing our growth has gone to under 2%, and yet there are opportunities potentially that come our way. And it's about the ability to be able to have the access to the right skill at the right time, so when an opportunity comes, you can take it, rather than sitting with a heavy staffing complement, which means you may not sustain yourself through a low in the economy, or conversely getting rid of all your skill, and then when an opportunity comes along you don't have access to that skill anymore, or at least quickly enough to take advantage. And then of course there's structural changes across the world in terms of geographic shifts, where we're seeing a lot of work is now being able to be done remotely, where for example European and US companies are outsourcing non-core functions. So, you know, the typical example we often see are call centers in India, for example, or IT development, and where they're able to use the differences in pricing structures and access to skills to their advantage. The demographic shifts, which I talked about briefly earlier, and then of course the fact that different sectors are happening. The world of work has changed. A lot of things in routine work is becoming automated, and the knowledge economy and the knowledge worker is now on the rise. When we look at the particular role that agency work plays, really what it does is it looks at how do you make the most of your workforce, and more companies are making sure that their permanent workforce component really is just the core people that they require on a daily basis. And the agency work component is what allows them the flexibility to ensure that they meet the demands of their environment, of the cycle, of the seasonality. And in fact, what has come out very strongly from this research and other pieces of research is that today, to remain globally competitive, most businesses need to have at least a 30% flex in their workforce if they want to be able to remain competitive and profitable. So what are some of the roles that a private employment service plays in the modern economy? Well, they have an impact obviously on the economy itself, in the sense that by being able to provide a better match of supply and demand, there's a greater mobility of labor market participation, and of course the ability to help speed up recovery. And if you have a look at this research, if you have time and are interested, you'll see that there is a direct correlation between the increase in our industry in particular as agency work, and as being an indicator of what's coming in terms of a recovery of the global markets, or conversely, when you start to see a downsizing in the number of agency workers out there, generally it's a predictor that things are not going so well and that companies are contracting in order to be sustainable. From a user organization perspective, which is obviously the area that I would imagine is of most interest to you, our industry provides access to talent and to obviously skilled workforces, and most importantly are able to help you manage the complexity of workforce planning. And I think we're all very aware of how complex the labor market is becoming in South Africa, with increasing amounts of red tape, increasing amounts of complexity in trying to understand concepts like equal pay for work of equal value, and how do you manage that effectively. And good private employment agencies, or as we're talking about them today, temporary employment service providers, are able to provide you with made-to-measure, customized workforce solutions based on what your needs are in your market, whether it's about high-level skill on specialist projects or whether it's about general workers on a productivity-based program, as opposed to just having people who are earning per hour. And then, of course, there are benefits to workers as well. Benefits in terms of access to the world of work, access to skills and development training, decent work. And yes, we do provide decent work contrary to some of the politicized rantings and ravings that we've seen over the last 5 years. And, of course, being able to provide people with the flexibility, because increasingly individuals are starting to demand flexibility in their own lives. Again, this just goes into a little bit more detail about the various areas, but I think I'll just skip through this in the interest of brevity, but you'll have access to these slides afterwards, is really just looking at how do the agencies help in terms of driving economies, how do they help to drive user organizations, and again, most importantly, it's about being able to provide tailor-made solutions, access to the right skill at the right time, and then enhancing your ability to operate your business as your core business and allowing the non-core functions, particularly managing HR, IR, and all of the complexity surrounding that. And again, also the benefits to the workers too. A slide I'd like to focus on, because I think it really does tell the story that flexibility is of critical importance. Part of this research looked particularly at this most recent global economic crisis and what the difference was between companies that were successful throughout this crisis or coming out of this crisis versus those that weren't. And this particular study comes from a study done in Germany, which looked at, and as we know, Germany is probably the most successful of the European countries in terms of what's happened. We've got the disaster areas in sort of Greece and Turkey and places like that, and Portugal, but looking really here at Germany as the bastion of sustainability. And they looked here to see, well, what made the difference in terms of companies, even within the German context, that were successful and those that weren't. And they looked across a range of things. So they looked at whether it was a big company or a small company, whether they were in the manufacturing sector or in a service knowledge environment, whether they exported or didn't, whether they involved in research and development. And across all of them, you can see a distinct advantage for those companies, which is the ones in green, that were using agency work. And in fact, if you look at the total figures on the right, you'll see it's almost double in terms of the success rate of companies that used agency work versus those that didn't. And fundamentally, what it boils down to is that when the economic crisis hit, the companies that had flexible workforces could downsize. Those that didn't, of course, downsized too, but they went through retrenchment processes, which, as we know, can be costly and time-consuming. And then, of course, they went to their absolute minimum core of employees. And if an opportunity came along, those that had downsized through retrenchment and got rid of skill suddenly didn't have the skill and capability or capacity to take on the contracts that came along. Whereas those that were able to continue to use their outsourced agency provider were able to take advantage, get the skill back on board for the period of time of the contract, and obviously take advantage of those business opportunities. We also hear a lot, and again, it's a highly politicized issue in South Africa, and particularly now as we head towards an election, about job creation and the argument about whether our industry creates jobs or whether it just facilitates access to jobs. And in the piece of research, there's a whole explanation on this graph, which I encourage you to go and have a look at. But in essence, what this is trying to show is saying, what would happen in the instance where a company had the opportunity to take on a new opportunity, new contract, but they obviously only have a small core function of staff. What would happen? So 54% of the time, they would use existing workers. And we know the age-old story, we retrench people, but the people that remain behind suddenly have to do two people's jobs for the same salary as they did before. 8% of the time, they just didn't even take the contract. They didn't even bid for the contract. They didn't even attempt it because they just didn't have the ability to do that. And obviously, there's no job creation that exists in that space. 12% of the time, they use some other flexibility solution, and obviously, some of them would take people on permanently. But what is interesting to see is that access to agency work obviously allows the ability for those companies to take up the opportunity and to move forward. There's a lot of really interesting stuff available in that piece of research, and I highly encourage it. If you don't have the time or inclination to wade through the full research paper, there is a great executive summary at the outset. And what is very nice to see is that South Africa, we participated in that process, and in fact, in some areas, including collaboration with trade unions, which seems contrary to what we hear in the marketplace about our industry, is we've got a world first in terms of the pilot project that was run by our industry with FEDUSA, the second largest trade union in the country, on giving access to social rights and protections and organizational rights and benefits to temp workers, as well as the creation of a provident fund that specifically caters for flexibility of temp workers and the ability to port between providers. So there's lots of really interesting things there, and I highly encourage you to look into that. I'd like to now hand over to my colleague Ati, who will take us through the technical stuff on the labour law amendments, and in particular how this will affect flexibility in your business.
Thank you, Natalie. Morning, everybody. I know that inherently, while going through the amendments to the labour law, everybody's going to become very, very negative. And I want to encourage you at the outset just to keep with me when we go through this, and you'll see that some people might see this currently as a very negative thing, where I believe this is actually a very, very valuable opportunity to distinguish your business from other businesses and actually to prosper. Now, there was a study done, international study, and Saki gave reference to this at our Cape's breakfast, that about 150 countries was examined, and out of 150 countries, it was found that South Africa was in the bottom 2 in terms of flexibility of our labour laws specifically. And it just emphasizes the position that it's so important to make sure that when you operate your business, that you actually have specialists and people that know what they are doing so that you don't incur any risks. Now, we've looked at 4 priority bills, and these are the bills that will have the biggest impact on your business. There's the Basic Conditions of Employment Amendment Act, the Employment Equity Amendment Act, the Employment Services Bill, and then obviously the Labour Relations Amendment Act, I think, which is a hot topic currently because for some reason everybody thinks that after 3 months a temp will become a permanent employee. And we'll get to that, and you'll see that it's actually not that. Out of these bills, there's 18 steps for any amendment to actually become law. Now, in terms of the basic conditions and the Employment Equity Act, they're already at the last step. It's been signed by the President, but not gazetted yet. With the Employment Services Bill and the Labour Relations Act, there were some amendments proposed at the National Council of Provinces, and it has to go back to the National Assembly for ratification before the President will sign that. Now, we all believe that these bills will come in at the same time, just before the elections, in a big fanfare, showing the progression that the ANC has made in terms of their promises to COSATU, and then obviously the support that they will derive from that. And that's the big thing. So everything that you hear roundabout now is going to be a whole lot of politicking. So I will take you through the facts. I'll show you what's written in the laws exactly, and you can make up your own mind to what the impact of that will be. But I can tell you that you're going to hear a whole lot of politicking, because to business, the President will say, no, it's joint and several liability. But to the unions and everybody else, he'll say, yeah, no, we kept our promise. The labour brokers are banned. And we'll go through this, and you'll see that it's actually not the situation. Okay, so here's the first 9 steps of a bill being passed and becoming law. And then obviously for most of them, well, for all 4 of them, we're now at step 17 and 18. Let's look at atypical employment and the deemed provision. And I think this is the sole reason why a lot of you have sitting in on this presentation. The amendment to Section 198 of the Labour Relations Act says the following, there's a 3-month additional protection for employees earning below the threshold, and that is then extended to becoming or being said that an employee in this category is deemed to be the employee of the temporary employment service provider as well as the TES's client. Now, deemed means that they do not become an employee of the client. It means there's a superficial relationship, a superficial employment relationship that extends to joint and several liability. Now, if you think about this, you already have joint and several liability in terms of the provisions of the Basic Conditions of Employment Act from day one. In fact, we've done a few cases where we've assisted corporates who have used non-compliant TES providers, you know, those fly-by-nights, and have incurred big debts. I'm talking about 10 million rands plus because their TES did not pay over levies to a bargaining council. So it's becoming more and more necessary for you to really vet your TES provider to make sure that they are compliant and that they actually provide a professional service and operate legitimately. Now, for purposes of the Labour Relations Act, after 3 months, the employee is deemed to also be an employee of the client. What does this mean? It means that in terms of any dispute that may arise out of the Labour Relations Act, the client and the TES provider will be jointly and severally liable. So if the TES does something wrong, the employee can decide who he wants to take to the CCMA. Likewise, if the client does something wrong, he chases the employer off site or something like that, now the client is also responsible and has to take the responsibility for such actions. Now, if we look at Section 184 and we look to the further support of our presumption that this does not mean that they become permanent, if a client of a temporary employment service is jointly and severally liable in terms of Section 184, or is deemed to be the employer of an employee in terms of Section 188A, an employee may institute proceedings against either the temporary employment service or the client. So here the act actually says exactly what we have been saying. So it reiterates and enforces the point that the employee does not become permanent. It just extends to joint and several liability. Globally, we see that the standard is about 12 to 18 months. Originally, it was negotiated to be 6 months, and obviously now the amendment will most likely go through on 3 months. So it's not something new. It's always been there, and this is to protect employees as well. So there is no transfer of employment after 3 months because the employee does not become permanent. And I think Natalie has now looked at some of the, and we'll go into the risks associated with you becoming too permanent or just getting rid of your flex work staff. But it's not something that you would want to do. Now let's look at the equal treatment provision, because this is another big thing. In the TES, after 3 months, it states that temporary employment services employees must be treated on the whole not less favorable than the equivalent employee of the client. Now, the intention of this is obviously a race to the top. If you have a transport company and you have permanent drivers that's been there for more than 10 years and they're earning a nice salary by this time, that a guy that's just qualified and come on board and obviously on day 1 of month 4, it's required that he now also earns the same amount of money. Now, this is not exactly true, and obviously the Act also makes provision that you may differentiate and make provision for different treatment of employees, and in Section 198D, some of these are listed. It may include seniority, experience or length of service, merit, the quality versus quantity of work performed, any other criteria of similar nature. Now, it's very important that you have a policy governing this, because this will be your fallback. If we look at the Employment Equity Act, at the Constitution, the presumption is always once there is a differentiation and this amounts to discrimination, you will have to prove that it's fair. There is something like fair discrimination, and therefore you will have to show that the differentiation or method of discrimination that you apply is fair. And you have to have a policy and then obviously consistently apply this policy. One of the great ways of getting around this, especially for instance if you look at call centers, is to make sure that you manage your employees on output rather than anything else. For instance, an hourly rate. So for instance, you're going to pay them R5 for every call that they make. Then that's a nice differentiator because now you're managing output and you're rewarding somebody that puts in more effort because obviously they're going to make more money, and that is not seen as an unfair differentiator. Now, part-time employees, irrespective of whether they work directly for the employer or via a third party, such a temporary employment service part-time employee earning under the earnings threshold, which currently sits at about 193,000 Rand per annum, and after 3 months of employment are to be treated equally to full-time employees. Now, you can still do fixed-term contracts, but here the biggest risk remains then how you manage the differentiator in the workplace. What's your policy going to be? Now, let's look at fixed-term contracts. Fixed-term contracts in excess of 3 months have numerous restrictions for employees' earnings below the threshold. Fixed-term contracts employees over 3 months must be treated equally to indefinite employees, and then 1 week remuneration per year of service to be paid for employees engaged in fixed-term contracts for a genuine project only kicks off after 24 months. So you can still have a project-based fixed-term contract that can run in excess of 12 months up to 24 months, but after 24 months you're going to have to pay retrenchment in conjunction with the minimum guarantee in the basic conditions, which is 1 week for every completed year of service. Now, in all practical ways, then this employee is actually, after 24 months, deemed to be a permanent employee. Although he's a fixed-term employee, for practical purposes, you have to examine that. Now, fixed-term contracts, the Act still provides that you can do a fixed-term contract and that it will not fall under the provisions of or the deeming provision. So without limiting the subsection 3, the conclusion of fixed-term contract will be justified, and then it lists those grounds. Replacing another employee who is temporarily absent from work. For instance, somebody gets into an accident and they're going to be off sick for more than 3 months. Is engaged on account of a temporary increase of the volume of work. Is a student. Is employed to work exclusively or on a specific project of limited and defined duration. Is a non-citizen. Is engaged to perform seasonal work. Employed for purposes of official public works. Is employed for position it's funded by an outside external source, or has reached the normal or agreed retirement age applicable to the business. So if you want to retain a transfer of skills after somebody who's coming up for retirement will have to leave, then obviously you can give them a fixed-term contract to facilitate that transfer of skills and capacitation of new blood in that or those positions. So the motivation and rationale for fixed-term contract is paramount to avoid usual employee rights and benefits becoming applicable. So make sure that when you do a fixed-term contract, it falls within that defined scope, and this is specifically applicable to people earning below the threshold, but likewise also in some instances then employees earning above the threshold. Make sure that you apply then project-based fixed-term contracts for a specific defined scope and period of time, and then obviously that won't become applicable. Retrenchments, and I think here is the biggest impact on your business. I don't think that the deeming provision will have much impact if you manage it correctly. I don't think that the equal pay for work of equal value will have much impact on your business if you manage it correctly. But here's something that you can't get around: retrenchments. Currently, you can quite easily retrench within 30 days following the consultation provisions provided by Section 189. And obviously, you don't need to reach consensus. You just have to show that you consulted as required. You can still unilaterally impose that that provision. But remember, there is no minimum consultation period recommended. So in the amendments, you're going to look at least 60 days required consultation, and that may be extended by request of either party, who may then not unreasonably withhold their permission, or if you're going to go to the CCMA for this, the facilitator may extend it past 60 days. So you're going to look at least 90 days consultation plus another 30 days notice. So that's 120 days. That's 4 months. So by the time that you realize that you are in trouble, that you might need to retrench, especially where you're now sitting with a bigger permanent component to your business, 4 months might just be too long, and you're going to miss the bus, and it will have a very, very detrimental impact on your business. So if you need to retrench, if you need to address flexibility components, in my view, you have about 2 months to do that. Think carefully before you permitize your workforce, because downsizing in the future will be an onerous and costly. Now, if you think about it currently, it's already very risky to retrench, especially when you're looking at smaller retrenchments, looking at the economical, technological, structural, other reasons. We've seen the labor court getting more and more involved in the merit of such retrenchments, and just going through the whole litigious processes, it just drags it out even more and more. So that's not something that you want to look at. I think it's better to manage your risk or outsource your problems or your risks to specialists who knows what they're doing, that will carry the risk, and obviously you just focus on the bottom line. Now let's look at some of the increased costs on business, especially SMEs that won't be able to, I think, manage this in terms of dispute resolution. 24-month security. So you go to the CCMA, you get a commissioner that really doesn't know what they're doing, you get the award against you, you want to take that on review, well, you're going to have to put down 24 months security. Now think about this. If you dismissed a senior person, a project manager, somebody like that, that's twice their annual salary that you're going to have to put down as security before you can even approach the labor court for a review. Basic conditions, removal of the compulsory undertaking and removal of employers' right to object and engage upon compliance orders. So we see a bigger discretion being given to labor inspectors of the department, and they can basically do whatever they want to. They can issue a compliance order or close your business, and if for that reason you under the revisions, you're not going to have the right to object or engage on that. Also, there is, in terms of the fines that's going to be proposed, additional 200% increase on those fines. So this just breeds a situation where you're going to see a whole lot of bribery and illegal stuff happening, especially if you don't know what you're talking about, if you don't know what they are saying to you is illegal or untrue. That just makes it so much difficult for a normal business just to run and do what they're supposed to do. Now, compliance is critical. Partner with an expert that can assist you in maintaining compliance and mitigating your risk. Natalie and I will now, after this very, very bleak picture, I think it's time for the good news. So what we're going to do now is we're going to look at a bunch of solutions and what your options are, and we're going to propose a way moving forward.
Great, thanks, Ati. I think obviously the first and foremost your option is to remain at the status quo, which is to retain your use of traditional fixed-term contracts and atypical or temporary employment via TES. Of course, as Ati's explained, it does carry the risks associated with joint and several liability, and particularly around the management of equal pay provisions, neither of which are a death knell to your business. It's just about making sure that you're using a TS provider that is compliant and who understands what the new changes mean and how you can set up infrastructure within your business. Of course, if you work within a bargaining sector or a sector that currently has sectoral determinations, etc., issues around equal treatment are possibly not as complex because you already have set minimums in terms of wages and associated benefits. Option 2 obviously is to remove the differentiator, and I think currently that's probably the option that a lot of companies are looking at, and their first knee-jerk reaction would be to say, okay, well, we've had these temps for a while, let's just make them more permanent. Or potentially say, you know what, we can't make them more permanent, so let's just actually get rid of the non-permanent staff. I think it's critical at this point to also remember that when we're talking about atypical or non-permanent staff, the issue is not about the temporary employment service provider or not about the labor broker. If you employ non-permanent staff directly within your business, you are equally affected by the provisions of equal pay and equal treatment. Of course, the challenge of doing this, either making everyone permanent or dismissing those who aren't and therefore only retaining your permanent staff, means that you are, as per the discussions in the research, pretty much putting yourself into a non-competitive position because you're removing that flexible component that allows you to adapt your business to changing circumstances. And so this is an option that I think needs to be carefully considered before jumping in the deep end. As Ati has just pointed out, if you do this and realize a month or two down the line that you've made the wrong decision, retrenching people is going to become a really expensive and really time-consuming process. So I think it's something that certainly, depending on the nature of your business, will determine your decision, but I think it is something to think of pretty carefully.
The other option you have, and this is the option that we would punt, is the hybrid model of functional outsourcing. Firstly, you're going to determine your core and non-core functions because you need to focus on what the core functions of your business are. What are those functions that's actually making you money? What's the reason for you existing? And do what you're good at because that's what you're good at. If you're an import-export company, then focus on that. You don't want to get into the grunt of managing your staff component, making sure that your HR is okay, making sure that you're compliant. Just looking at the statutory requirements of compliance becoming more and more burdensome. I mean, we're the second least flexible country in the world in terms of statutory compliance. There's a whole lot of stuff that you need to think about. And while spending your time and your money and your efforts on this, then inherently your core function or the reason for your business existing will start to struggle. So then outsource all non-core functions on a functional level. Now, how to do that is obviously you can retrench all of your non-core functions and outsource that to a service provider, or you can put a freeze on hiring on those levels and only use and outsource that function. And then obviously through time, work out through death, resignation, dismissal, you know, the normal ways in which an employment relationship terminates. You can then over time work your way into a totally functional outsourcing model where you will then retain a flex component in terms of all non-core functions. And then in terms of your core functions, identify what are your core functions and identify within that where you're going to need flex components. For instance, special projects where you're going to need to employ a professional. There you might need to employ them on a project-based fixed-term contract. That's fine. And obviously you have a compliant TES provider who's a specialist in this and will be able to assist you. And that's the best option to maintain flexibility with mitigated risk, and it will allow your business to focus on its core reason for existence.
I think information overload in some senses, but hopefully to provide cut see the wood from the trees, as the saying goes. What we'd like to do now is obviously ask those of you who have questions, and I see we do have questions, to answer those. So let me go to the question section and we can see the questions and we can go through these one at a time. Great. So in terms of a fixed term contract or temporary employee, does benefits also have to be equal, i.e. pay for medical aid and pay for provident? Ati?
Yes, the provision says on the whole, not less favorable. So if you do not give them a medical aid, you have to give them the means of acquiring such. So equal pay or the equality provision will apply, but especially to those employees earning below the threshold, which is 193 per annum.
Great. In terms of retrenchment, the question is, the minimum of 60 days, does this apply to permanent employees only?
It will apply to permanent employees and then obviously fixed term contracts in excess of 24 months where you're going to have to pay severance. That's the 1 week for every completed year of service.
The slide deck will be made available, as will the recording. Are there any other questions at this stage?
Leslie, I think we had one question submitted electronically previously that says, how does one differentiate between a TES and a consulting company focusing on specialist skills? So both put people on site on a contract basis, so what would really be the difference?
Mainly your focus will be on a few things. Firstly, who is regarded the employer, because there's a difference in terms of the traditional TES or labor broker where you just tell them I want X, Y, and Z and whatever, and they come and provide that to you, and where you outsource that function, where you're going to manage your or the service provider on an output base. For instance, you outsource your picking packing division and you're going to say I need 50,000 crates per month packed, and how you get to that, how many people you employ, who you employ, it doesn't really matter as long as you get that done. You get one invoice at the end of the month from your service provider and you pay them. That's a functional outsourcing or the independent contractor, so to speak, because you don't give them the tools, the methods or the means. You just tell them what is the result that you require and they provide that for you, opposed to you still having control over the employee that's on your site. That's the traditional TES model.
Okay, and actually then I think we had a second question which is related, and maybe it also brings into question the earning the biggest portion of your income from a specific client. Somebody wants to know, they have been contracting for 7 years, only working as a contractor and never permanent. How does the amended legislation impact on this person doing contract work for one specific company or companies 2 to 3 years at a time? And my understanding from the question would also be that the majority of their income would come from one company.
Firstly, you'll have to differentiate and make sure to find out if this person will be regarded an independent contractor who is managed on output or an employee on a fixed term contract for a specific period of time or for a specific project. If it's the latter, then obviously you will be entitled to retrenchment benefits after 24 months. If it's the first, then you're an independent contractor and this is not applicable to you.
Yeah, the independent contractor versus disguised employee is an interesting conversation, and certainly one we have an article which is available if anybody's interested in reading that. But in essence, my understanding, and here I put my hand up, I'm not a lawyer and I defer to Ati on this, but my understanding is if someone's earning more than 80% of their income from a single source, it's quite difficult to be able to convince SARS, because that's where the independent contractor versus disguised employee sits, is within SARS. And the 80% criteria obviously is usually what's used to determine whether you are truly independent. Of course, under SARS, there is the ability for an independent contractor to secure an IRP 30, which they would then provide to the company they are contracted to, which would allow the company to know for certain that they are qualified under SARS as an independent contractor and therefore not entitled to employee benefits or taxation as an employee. So I think in that case it would be important for the client, if you're dealing with independent contractors, and often these are highly skilled professionals, whether they're IT or engineers, is to make sure that you just have your ducks in a row by checking that they are correctly registered and have an IP30 so that you don't end up being, SARS knocking on your door and saying you should have paid PAYE and benefits. There's a question here, are the amendments to the Act applicable to internationally temporary resources as well? I'm just trying to understand the question. I think if you're inferring an international person who is based in South Africa and working here, Ati, I defer to you, but I would imagine that if they are working in South Africa, South African labour law applies to them?
In terms of conditions of employment, yes, and if you refer back to the amendments to Section 198, especially those focusing on fixed-term contracts, there a foreigner was defined as a person not then being affected by the specific deeming provision. So in that sense, no. But if it's a South African citizen employed by a South African company on loan and or work, then going to work on a project or something else in another country, South African law will still be applicable because South Africa is where your domicile will reside.
So actually, just from a layman's point of view, to clarify, if I employ a Zimbabwean citizen on a contract, this will not apply. If I have a South African person that works for me as a South African company and I send them to go and do work in Zimbabwe, it will apply.
Yeah.
In summary?
Yes.
Okay.
I tell you a question. We have a situation where an employer was on a 3 months probation. We extended the probation by another 3 months. Is this legal?
Well, probation under amendments is also falling away, but we've seen the practical implications of managing a person under probation for some years now, where the courts and the CCMA have just said, well, irrespective of whether or not you're on probation or if you are a permanent employee, the process of managing such a person under poor work performance, for instance, remains the same. So practically there's no difference. So although it was recorded in law that there's a difference, the process to be followed was exactly the same. So where you can extend, where you extended the probation, that's fine. You can extend it, I think, generally as a rule of thumb, not past 6 months. But the process that you had to follow if you're going to dismiss this person will be exactly the same as the process that you would follow getting rid of somebody for poor work performance that's been there for 10 years.
If you pay more than 1 week, can you negotiate a reduced consultation period for retrenchments?
No, because the Act now provides a minimum consultation period of at least 60 days.
What is the rationale behind the 24-month security to be lodged during a review of a CCMA?
Okay, basically it's a whole lot of factors, but in my opinion it relates to specifically an employee being prejudiced. So where the CCMA, for instance, have ordered reinstatement or retrospective reinstatement, taking the matter on review to a labour court might take you at least getting it on the roll between 9 months and 3 years. So good luck with that. And in that period of time, the employee still then remains unemployed. So the security, so that it's not just a delaying tactic, is there built in to say, oh, I definitely disagree with the award of the commissioner, therefore we're taking it on review, and then obviously you have to provide security, which is that 24 months.
So actually linked to that question, somebody had written in to say, how do we get rid of a burnt out employee who is not interested? And I think it is about understanding the process of performance counselling. So if you can just maybe give us a bit of a summary to make sure people stay compliant.
Okay. Obviously there's always the formal and the informal route that you can take. In terms of an informal route, I would suggest that you sit down with the employee and have a discussion without prejudice of rights. Try and find out what the reason is and if there's any way of retaining the relationship on a positive level. And if it's very clear that the employee doesn't want to stay, you have one of two options. One, you can sit and negotiate the terms and conditions associated with a mutual termination of employment and then enter into an agreement that is in full and final settlement of that. If you're going to manage an employee to, in terms of poor work performance, you need to have at least 3 meetings. You have to identify the performance standards against which you're going to measure them. You have to make sure that they are reasonable, objective, and fair, and that you can clearly identify what those are and measure them. You have to establish at what level the employee is functioning. You have to provide for measures of capacitation and making sure that this employee has a fair opportunity to actually reach those performance standards. And in a second session where you're going to benchmark the employee yet again, and if they're still not up to level, then a third meeting where you may dismiss this employee. Now at that meeting, these meetings should take place at a reasonable period of time to assess their performance. So it can't be Monday, Friday, and next Wednesday you're out. Okay, so you need to make sure that there's at least, I would say, generally 2 to 3 weeks in between these meetings. So you might end up with 9 weeks, which is almost, in any case, 2 months. So it might be more to your benefit and not even calculating or quantifying your time and effort spent on this, just to sit down with the employee and come to an agreement what's going to be a full and final settlement, obviously if they're up for that. If not, then you have to follow this process.
Question now just saying, well, talking about which jurisdiction exists, they're saying what happens in the case of an international company with resources based internationally but working on projects in South Africa?
The projects will fall under the domicilium of South African law, and South African law will apply to those projects specifically. In terms of employment law related issues, in as far as you employ resources within South Africa, it has to be within the South African law. Because remember, if it's legal to build bombs overseas, it doesn't mean because you're a citizen of that country you can come into South Africa and the South African laws aren't applicable to you. So the provisions of South African legislation will still apply to those projects.
To answer the question, has there been any talk of challenging the constitutionality of any of these changes by political parties? I'm not aware of any political party specifically saying they would challenge the constitutionality. We have looked at that as an industry, but I think at the end of the day, it's going to come down to the interpretation of this. I think the challenge we have faced as an industry is that things like the deeming provision and the way in which it's been written, and I think more importantly, the way in which it's being communicated in the broader marketplace, creates an uncertainty. What we anticipate, however, will be that once it comes into law, because of course even the two, the Employment Equity Bill or the Employment Equity Amendment Act and the Basic Conditions of Employment Act, although they have been signed by the President, because they are not yet gazetted, they are not in force. So current legislation exists and continues to maintain. What we anticipate will happen is once the legislation has been gazetted and is therefore promulgated and in effect, we will then see how that deemed provision is interpreted, whether it's at CCMA level or at a court level, and based on that we'll determine how we move forward. Whether there would need to be a constitutional challenge, I guess, will only be determined into the future. But as we've said, we do believe that they are workable. The challenge, of course, I think for us as South Africans is that we already are so far behind the rest of the world in terms of the inflexibility of our labor markets that, you know, just adding the burden of administration and trying to keep on top of all the complexity is really where the challenge is. And again, you know, what we suggest here is where you are able to partner with a professional organization like you guys do with ProTem, that's really what we would recommend, is make sure that you know what's happening, know how it impacts on your particular business, and make sure that you've got the right checks and balances in place to ensure that you're managing all of your various kinds of staff members and depending on their contracts in accordance with the law.
Now, I am aware of several litigious challenges currently underway and currently within the courts on various aspects of the labour law amendments. I can also confirm, maybe just to put you at ease, that business organizations are keeping their options open, but at the end of the day, we need to make sure that we work smart and that we work out solutions that's in the best interest of business. And currently, other than a few things, there is not such a big risk on business if we manage this smartly. And I can tell you that there are people doing the fighting on the front lines and making sure that business is protected. So if there's something unconstitutional and all of that, that fight is being fought. But in terms of implementation, where you guys are going to be affected, we have solutions, and we will want to punt that you buy into these solutions, and in terms of business, make sure that you follow and be assisted by compliant and professional TS providers.
Great. The question about how will you go about not renewing internships, if you refer back to the fixed term contracts, it does make provision for students and graduates who are employed on a fixed term contract specifically to do with skills transfer. So internships and learnerships would fall in that same space. And again, it would just be about making sure that whoever is your labor law or legal consultant, make sure that that contract is specifically worded to ensure that it's aligned to the time period or the requirements of that internship or learnership program. I think those are all the questions that we've had. If I can ask if anybody's got a last minute question, because we are fast approaching the hour, please to quickly write it now. Otherwise we will end the broadcast. If you have any other questions, I'm sure you can send those to Vicky and her team, and we can certainly give some input from our side as well if that would be of assistance.
Absolutely. So in closing, thank you, Natalie, thank you, Attie, for sharing your time and your knowledge with us. We really appreciate it. Just to reiterate what Natalie said, you can please forward on any questions to myself, and we'll make sure we get an expert to answer them for you. We will be posting a recording of the webcast on our website for you, as well as the research and the presentation that Natalie referred to and that you saw today. And hopefully in the near future, we will also be scheduling some follow-up sessions. So if you are interested in attending webinars like these more regularly, please let us know. But thank you so much. I think we're spot on time. It was an excellent session. And we hope to speak to all of you again soon.
Thank you very much. Thanks, Vicky.
Thanks.